Hello and good morning. Thank you so much for joining me today. Today on this Wednesday webinar, we are going to discuss Social Security disability for anxiety. And today we are going to start out with a little bit of talk about Social Security disability basics, what the programs are, how they operate, talk a little bit about some Social Security guidance as it relates to anxiety claims, potential listing 12.06, which is the listing for anxiety claims, additional considerations, and then, of course, as we close out all Wednesday webinars with some of the ways an attorney can help you with your Social Security disability case. Before we go any further, I do want to make sure to mention that this webinar is not legal advice. All legal cases, especially Social Security disability cases, are very different. And so it's impossible for me to give blanket advice, but instead this webinar is meant just from an informational perspective to give you a little bit more information and background into Social Security disability cases that relate to anxiety. And then if you do have specific questions about your situation, I do include contact information at the end. If you are watching on the live, we will put into the chat a link to schedule a call with me. And then if you are watching on a replay, there will be a link down below to schedule a call. Again, if you have any questions as it relates to your Social Security disability case, whether it involves anxiety or not, any questions, please always feel free to reach out. Always happy to help wherever we can. So with that all being said, a little bit about me. My name is Kaitlin Wildoner. I'm the founding attorney of Beacon Disability PLLC, which is a law firm based in Florida, and we exclusively practice federal administrative law, specifically focused on Social Security disability cases at the agency level, which is the initial application, the reconsideration stage, the hearing stage, and then the appeals counsel stage. We do not handle federal court appeals. However, if you do have a federal court issue and you have questions about, feel free to reach out and we can see if we can connect you with someone local in your area that does handle those federal court appeals. Okay, so Social Security disability basics. There are two different programs, and all the time clients get confused. They don't know which one is which. They didn't even know maybe there were two, but there are two. The first program is Social Security Disability Insurance, SSDI benefits. And SSDI benefits are benefits that are based on what you were able to pay into the system while you were able to work. And so with that, you have to have a sufficient number of work credits, a sufficient work history. Generally speaking, we say that that's 5 of the last 10 years. The other program, Supplemental Security Income, or SSI, does not have a work history requirement, but instead it has income and asset restrictions. You cannot have above $2,000 in assets if you're single and above $3,000 in assets if you are married and still qualify for SSI. However, where the programs collide and where they are the same is they both require that you be disabled and unable to work for a period of at least 12 months due to physical and or mental impairments. So that means that Social Security disability, neither program is there as a temporary Band-Aid for a problem existing less than 12 months. You have to either already have been out of work for at least 12 months or be expected to be out of work for at least 12 months in order to qualify for either SSDI or SSI. And again, the reason for being out of work has to be due to at least one or more severe medically determinable impairments, physical and or mental. Once you apply for Social Security, after they get through and see, okay, is this an SSDI claim? Is it an SSI claim? They're going to look to kind of start to evaluate your medical portion of the case. And they are first going to see, are you engaging in substantial gainful activity? Right now in 2022, when this video is being recorded, substantial gainful activity is $1,350 a month in gross earnings. So if you are working and you are earning more than $1,350 a month in gross earnings, or if you are working more than 20 hours a week, then you will not be able to be found disabled by their definition. If you are engaging in substantial gainful activity, the case evaluation will stop there. Social Security will look at it. They will say you are engaging in substantial gainful activity, and therefore, by our definition, you cannot be found disabled. If you are not engaging in substantial gainful activity, the case will move to step 2, where the agency will look to see, okay, do you have any severe medically determinable impairments? They're going to look at the medical records. They're going to see what the doctors are saying, what the objective imaging and findings are saying. Do you have a severe impairment that is preventing you from working in some way? And if you do not have any severe impairments that are preventing you from working, the case evaluation stops there. If you have at least one severe impairment that's preventing you from working, that can be kind of, bolstered by the medical records. Sorry, I have a cold today, which is why I was leaning over earlier. My brain is not working at its peak, but if you have at least one impairment that's preventing you from working, then the case will move to step 3, and they will see, okay, you've got at least one severe impairment that's preventing you from working. Do you meet or equal a listing as it relates to that impairment? If you do, the case evaluation will stop there, and Social Security will send you a favorable decision. If you do not meet or equal a listing, Social Security will move to step 4 and determine, okay, you've got these severe impairments. Do they prevent you from going back to your past work? And to do that, Social Security will create a residual functional capacity for you. And they base that residual functional capacity, that RFC, on the medical records. You might already have an RFC in the medical records, and you might not. They might have to cobble it together based on some doctor's notes. They use that RFC to compare it to the Dictionary of Occupational Titles to see, okay, can you go back and do the past work with these impairments? If you can, then you will be found not disabled. If you cannot go back to your past work, the agency moves to step 5 to say, okay, you can't go back to your past work with your RFC, but can you engage in any other work that exists in the national economy? And if you can, if there are other jobs that you can adjust to, then that's when you will also receive a denial. If you cannot engage in any other work, you cannot make any adjustments, then Social Security will send you a favorable decision finding you to be disabled. Okay, so turning to anxiety cases specifically. The listing for anxiety that we'll talk about in a minute also includes obsessive compulsive disorders. And as far as Social Security is concerned, anxiety and obsessive compulsive disorders are characterized by excessive anxiety, which isn't that defining something by using the word. But anyways, excessive anxiety, worry, apprehension, fear. Or if you avoid certain feelings, thoughts, activities, objects, places, or people. So they start out by kind of defining it by using the word, but then they give us a little bit more information as to what they are going to be looking at in those medical records. And then specifically signs and symptoms of all of that might include restlessness, difficulty concentrating, hypervigilance, muscle tension, sleep disturbance, fatigue, panic attacks, obsessions and compulsions, constant thoughts and fears about safety, and frequent physical complaints. If you have also got a trauma or a stressor-related disorder, such as PTSD, that is not evaluated under this listing we're going to talk about in a minute. That's evaluated under a separate listing. Unfortunately, PTSD patients often do also have a component of anxiety to it, but that is evaluated under a different listing. If you've got PTSD and something like a generalized anxiety disorder or a social anxiety disorder, then you can kind of look at both of the listings. When it comes to medical records, if you've watched any of the webinars before or any of the videos that I have recorded before, you have likely heard me say how important medical records are in Social Security disability cases. They are critical. Social Security will consider all relevant medical evidence from your physician, psychologist, any other medical sources, including if you go to the doctor and you typically see a PA or a nurse practitioner, or if you go to counseling with a licensed clinical social worker or a clinical mental health counselor. All of those records will come in. And as you can see below, there's some of the medical evidence that might be included in those records. What I will say is it can be tough sometimes to find a provider that understands you when you're dealing with a mental health condition. mental health kind of reaches the deepest parts of us. And so it's not something as simple as just going to see a primary care doctor who's going to check your weight and your height and make sure you're all good, answer any general questions that you've got. But because you're getting deep down in there, you want to make sure that you've got a provider that listens to you. So that's very important. The other thing that's very important from a Social Security perspective is that that provider is then taking notes. Not all licensed clinical social workers and clinical mental health counselors take notes that they can release to Social Security. So make sure, particularly with respect to mental health cases like anxiety, depression, PTSD, if you are seeing providers for your mental health, which is wonderful, and you're getting along with them, which is great and super important for so many reasons, let them know that you are applying for disability and that their records are going to be an important part of that. And that way they know that their priority is always going to be treating the person that's sitting in front of them, but that their secondary important piece of their role with you is making that medical chart and that timeline. So that way Social Security can see what's going on. So that's just a little note and a helpful hint based on difficulties that I've had. Like I said, that tends to, and part of it is because I'm in Florida, we've got certain, and HIPAA, I think generally has different protections for mental health related records because they are so intimate and personal to us. But just make sure that you're talking with them, letting them know that you're applying for disability. And if that means that, they might not be able to release the total whole record, but they can instead write a letter. And we see a lot of our licensed clinical social workers that are so fabulous that do that. And those can be very, very, very helpful. So word to the wise about medical records. Now, talking about the listing. 12.06 has two different avenues to a finding of meeting the listing. As you will see, A is in both of them. So here are the requirements of A, 12.06A. It requires medical documentation of one of the three, either anxiety disorder, which is characterized by at least three of those first set, which is restlessness, easily fatigued, difficulty concentrating, irritability, muscle tension, or sleep disturbance. So that's one. If you've got that, then you meet 1206A1. Okay, 1206A2 is panic disorder or agoraphobia with either panic attacks followed by a persistent concern or worry about additional panic attacks or their consequences, or a disproportionate fear or anxiety about at least two different situations, whether it's using public transportation, being in a crowd, being in line, being in open spaces. So panic disorder or agoraphobia, one or both of those. That's 1206A2. 1206A3 is obsessive compulsive disorder, and again, characterized by at least one of the following: either involuntary, time-consuming preoccupation with intrusive, unwanted thoughts, or repetitive behaviors that are aimed at reducing your anxiety. So if you meet at least one, 1206A1, 1206A2, or 1206A3, and here's where kind of the fork happens. You can either, well, we already had a fork, but here's our second fork. Have an extreme limitation of one or marked limitation of two of the following areas of mental functioning, and that's your ability to understand, remember, or apply information, your ability to interact with others, your ability to concentrate, persist, or maintain pace, or in your ability to adapt or manage oneself. So you've got to meet 1206A, one of those three. You have to meet that in order to meet or equal the listing. And you can either meet B, which is an extreme limitation of one of those four, or a marked limitation of two, or you can meet 1206A and 1206C, which is that your mental disorder in this listing is serious and persistent, meaning that you have a medically documented history of the existence of the disorder over at least 2 years, and there is evidence of both medical treatment, mental health therapy, psychosocial supports, or a highly structured setting that's ongoing and that diminishes the signs and symptoms of your mental disorder, and that you have the marginal adjustment. That is, you have a minimal ability to adapt to changes in your work environment or to demands that are not already a part of your everyday life. Okay, so you can either meet 1206A and B or 1206A and C. Those are the two different avenues. And as you can see, really to meet 1206A, there's 3 avenues there. Okay, some additional considerations as it relates to Social Security, disability, and anxiety. As is always the case, medical records are paramount. And the issue in Social Security cases is not just, can you go back to your past work, but are there any jobs that exist in the national economy that you can do? And if you are 50 or older, the grid rules might apply. However, the grid rules are particularly relevant if you have physical impairments in addition to your anxiety and any other mental health concerns. Okay, the grid rules are not so helpful for mental health only claims, but instead focus more on the physical because it does look at, it puts you into different categories, sedentary, light, medium. And so that's really where they come into play. And functional capacity can also be relevant, again, particularly if you have physical impairments in addition to your anxiety or mental health concerns. Again, medical records are important, especially objective medical records, but these are so hard to get in mental health cases. So it's important to have a treating provider who understands what you're going through, can properly document the file, and connect it back to your anxiety. As I mentioned before when we were talking about medical records, well, I didn't mention this part, but that tends to be the hardest part about the mental health cases because it's so easy to be misunderstood. I always tell clients, a back disorder can be found on an X-ray, a CT, an MRI. Anxiety and depression can't. It's something that you feel so deeply, and it's not always visible from the outside. And so that's what can make these cases so tough. And so that's why it is important to have not only a provider who understands what you're going through and can help document the file, but also an attorney and law firm on your side who understands that and will work with you to try to put the best case forward, especially if you've got anxiety as it relates to being in an unknown situation, like before an administrative law judge in a hearing. So those are additional considerations to make as it relates. And then how can an attorney help you? This is just a short list. This is not everything we do, but these are kind of the questions that I field the most often. We do provide guidance on what correspondence from Social Security actually means. That is not just the denials, but also the forms that they send to you that they need you to fill out, what kind of information they're looking for. We don't fill them out for you because you are the only one that know what you go through on a daily basis. We can empathize, we can listen, we can understand, and we can review those forms, but I kind of like to call them testimony without having to go before a judge because it gives you an opportunity to explain what all the medical records actually mean for you in your situation, what you're dealing with on a daily basis. We help file necessary appeals. If you're already a client of ours and you get a denial letter, say, hey, got my letter, and ours is usually either coming in the mail that day or a couple days later. We'll file that. If you get your letter and you don't have a lawyer, if you call the lawyer within a certain amount of time, they might be able to help you with that appeal. We help to review your medical records in your case file, and in that vein, might be able to discuss what additional records would be helpful for your case. We can, like I said, we don't fill out the forms, but we can review them for accuracy and completeness. As I said, we discuss what Social Security might be looking for in their forms. We work with you and Social Security back and forth to provide relevant updates back and forth throughout the claim. If you have to go to a hearing, we prepare you for that hearing as you are the primary witness in that hearing, which unfortunately tends to stress a lot of our clients out. But we will question you and any witnesses like a medical expert or a vocational expert during that hearing. Okay, so in the same vein as why, well, I don't think I mentioned it this time, but why this is not legal advice. I don't answer any questions on the live, and I do not answer any questions that have super specific facts in the comments on the replay. And the reason for that is, as I did mention at the beginning, every case is different. If you do have questions, please, please, please reach out. On the live, we did put the link to schedule a call in the chat. On the replay, it will be down below. Please feel free, give us a call, send us an email, schedule a call. We are happy to help in any way that we can. And if we cannot help, we do try to connect you with somebody who can. So that is all for today. Thank you so much for watching and have a great day.